Association to welcome you to the EYBA Spring Conference in Rome. My name is Shannon Gawley, and it is fantastic to have you in this historic and vibrant city. And might I add, how spectacular it is to be in this building today. I think we can all agree it is getting the conference off to a great start. I particularly would like to welcome those of you who are attending your first EYBA conference. It is fantastic to have you, and I do hope it will be the first of many. So this year's theme is Contemporary Legal Challenges of the European Landscape, and it could not be more timely. I do feel as young lawyers, it is important to highlight these evolving issues that we do have to face, from human rights to the growth of AI, technology, and environmental issues. And over the next few hours, we do have the pleasure of listening to a number of distinguished speakers who will share insights into these pressing issues. So, without further ado, to officially open our conference, it is my honor to pass the floor to the President of the Rome Bar Association, Paolo Nesta.
It is a great honor for me to welcome you to Rome for the EYBA Spring Conference, which is taking place in the solemn palace of the Court of Cassation, the highest judicial authority in Italy, where the Rome Bar Association has its premises. The venue of high historical value represents our commitment to justice, the rule of law, and the values that unite attorneys in Europe. The theme of today's conference, Contemporary Legal Challenges in the European Landscape, is extremely timely. We are living in an era of profound transformation, driven in particular by technological innovation, new regulations, and the increasing complexity of global legal issues. We lawyers are called upon to use our skills and experience, always guided by an unwavering respect for the principles of justice, equity, and professional ethics. Today, as legal practitioners, we face new and complex challenges that must be addressed with an ethical vision and the capacity for innovation. I can mention artificial intelligence in the legal sector, environmental, social, and governance compliance, protection of fundamental rights in the digital age, the ongoing evolution of cross-border disputes, and international legal cooperation. In this context, the contribution of young lawyers is fundamental, representing the future of our profession. Their dynamism will help shape the legal landscape of tomorrow, crossing national boundaries and strengthening the European and international legal community. Moreover, this conference is a unique opportunity to forge professional relationships, exchange ideas, and create ties. Dialogue, cooperation, and mutual understanding are the foundation upon which we must build the future of our profession. Finally, I wish to express my sincerest gratitude to the European Young Bar Associations and to the organizing committee chaired by Giulia Guagliardi for making this event possible, gathering speakers who will offer valuable insights. On behalf of the Rome Bar Association, I extend the warmest welcome to all participants and I wish you a productive conference. Thank you.
Good morning to everybody and welcome to Rome. I'm here representing the International Bar Association, but I am from Rome, so I'm very proud that you are here. Italy is becoming more and more active in the field of international organization and associations. We hosted the Union Internationale des Avocats conference a couple of years ago. We were here in 2018 for the annual conference. So we are, I think, very, very happy that Rome is regaining a position it didn't have before in terms of international exposure. And I think this is very important also for our young lawyers in Rome, being in an environment which is international and open to a lot of interesting inputs. As the president just said, we are living in a very peculiar time that probably we didn't expect to have to be confronted with. In particular, erosion of rule of law and independence of justice is becoming more and more concerning. And I think that particularly for you, young lawyers who have an entire career in front of you, it is important that we all act to protect these core values of our profession. The attack that is taking place in, particularly at the moment in the U.S. Against really independence of the legal profession is very concerning. The IBA, the International Bar Association, took a very strong position on this issue. We issued a very short but very, I would say, precise press release a couple of days ago after a number of US law firms had been the object of sanctions. Of course, there was a lot of let's say, concern in finding the right words because even the firm who were the direct target of these sanctions were very careful in reacting. But we felt that as an international organization, we have to take a position without any really qualifications. I'm reading to you what we issued because I think is important to share it. The International Bar Association expresses deep concern over the ongoing erosion of the rule of law in the United States. Recent attacks by U.S. administration on judiciary, the legal profession, and the media, each a vital pillar of democracy, have created a chilling effect both domestically and internationally. As a global leader, the U.S. must uphold these fundamental principles which are essential to democracy and the rule of law. This is unfortunately not the first time that this is happening. Less than a month ago, the ICC, the International Court of Justice, was the target of sanctions which were threatened and in part applied. We see, with the rule of law under attack in countries in which we would never have expected this to be an issue. I think we have to be all conscious of this. The IBA is now considering revitalizing a project we had in 2018 in the framework of which we published a series of videos which are explaining in a very elementary way what the rule of law means. And what we are planning to do is to really spread these videos in schools and university just to really convey the message to young people, young lawyers, people who will really be the backbone of the society in the future. So my recommendation is let's look at substantive law issues, and I think there will be a lot of very important topics we will be discussing here today, but let's not forget that rule of law and independence of justice are key in our profession. Thank you.
Claudio, the microphone. Good morning, distinguished colleagues, friends. It is an honor to welcome you in Rome for the Spring Conference 2025. I will start my welcome remarks with a flashback to 6 years ago, when I was sitting in this exact same place, introducing the EYBA Summer Conference 2019. At that time, I was a member of the Rome Young Bar Association. My experience in the EYBA had just started, and I was not even part of the Italian Association of Young Lawyers. As we say in Italy, a lot of water has passed under the bridges since then. During these 6 years, I grew up in EYBA until I became president in 2021. I joined AIGA Roma, which since 2023 I have the honor to chair. And if 6 years ago someone would have told me that I would have organized another EYBA conference in Rome, I would have not believed it, and probably I would have refused the idea of jumping again in such a challenging organization, especially during the Jubilee year, which made everything even harder. In this regard, I would like to thank the members of the organizing committee who worked very hard to put together this program. Behind what you will see during these 3 days, there are 9 months of commitment, small and big details to guarantee to all of you a good experience in our city. I also thank the Bar Council, the Rome Bar Council, for allowing us to use this wonderful venue, the House of Lawyers, in such a prestigious building. The support guaranteed by the Rome Bar Council to young lawyers should not be given for granted. And we hope it can represent an example for other European bars, especially now that almost everywhere in Europe, less and less young people decide to pursue the legal career. Indeed, the new generation are questioning whether law is still the right path, whether it can still inspire, empower, and make a difference, whether it can guarantee a sustainable professional life. And this is probably due to the fact that, at least during the last 40 years, there is a drop in the public's perception of the character, prestige, and ethics of lawyers, in parallel with the public distrust and popular skepticism about the judicial system in general. This is something we should all care a lot about. And investigating the causes for this drop in the public's perception is really hard, and there are several factors that contributed to worsening the condition of the legal profession, but for sure, we also bear some responsibility. The economist Kenneth Harrow has written of trust as a public good that increases the efficiency of any system, but that cannot easily be bought. So what can we do? I think we should work on ethos and ethics, where ethos is why we do what we do, and ethics is the how we do it. We should embrace the crucial role of lawyers in the civil society. We should communicate better with the civil society. I think lawyers need to work on their language because words are bridges. And we play a key role as intermediaries between the justice system and the public at large. We should act as a group, proud to be part of a category. Members of the legal profession should share a common commitment to something greater than our own self-interest, and of course, high qualification and training. These are all principles and aims we are inspired by when we organize events such as this one. The world is changing, technology is reshaping the way we work. Global challenges demand new legal frameworks, and societies are calling for a more accessible justice. So who better to lead this transformation than the new generation of lawyers? Fresh perspective, digital fluency, adaptability, these are not just skills. These are the tools that will redefine our profession. And this conference is an opportunity to learn, to connect, to inspire one another, looking beyond the national borders. As here today, we have colleagues from more than 20 different countries, different cultures, backgrounds, languages, areas of practice. But more than that, this conference is a call to action. Because the future of law is not written in statutes or in case law, it is written in the choices we make, in the values we uphold, and in the impact we create. So I urge you to be bold, be innovative, and never lose sight of why you chose the legal profession in the first place. Because law, in my opinion, is not just a career. It's a noble calling, a vocation in which we can make a difference in the lives of people and in the welfare of society as a whole. Because law is the architecture that sustains the world. And the world needs young lawyers to answer that call. Last but not least, I would like to thank all the speakers, the moderators, and I'm very grateful to all the sponsors of this event, the law firms Legans, Advant NCTM, Gianni Rigoni, and the Center for American and International Law, and our supporting partners, the Rome Bar Association, the Milan Bar Association, the Turin Bar Association, the Italian National Association of Young Lawyers, and the Association of Turin Young Lawyers. Again, I thank you all for coming from so many countries. We really hope this conference will leave you unforgettable memories, and I hope we can shape the future together. Thank you very much. Grazie, thank you. Now I will leave the floor to Carlo Fogliani, my colleague, my friends, the president of the Italian Association of Young Lawyers.
Thanks. Good morning, everyone. It is with great emotion and huge pride that I greet all of you on behalf of a Italian Young Lawyer Association on the occasion of prestigious EIBA Spring Conference 2025 here in the splendid setting of Rome. This event represents a unique opportunity to build a bridge, share experience, and create together solid foundation for the future of our profession. The European Young Bar Association has been the big heart of a network of young lawyers who believe in the power of collaboration, innovation, and are conscious of the need to face with determination all the change we coming to our nowadays. Your presence here is proof that the new generation of lawyers are ready to take up the torch and lead the change with courage and vision. Sincerely, thank you to EIBA for its constant commitment to promoting dialogue among young legal professionals and for its extraordinary ability to build a solid and dynamic international legal community of which IGA is proud to be an integral part, actively to contribute to its growth and strengthening. We are living in an era of unprecedented transformation. The digitalization of justice is completely changing the way we work. Artificial intelligence is redefining the building of law, while European regulations are evolving at a pace that requires constant updating. But we cannot be mere observers of this change. We must be protagonists, capital anticipating the future, shaping it with our preparation, commitment, and passion. The EIBA Spring Conference 2025 is not just an opportunity for training and networking. It's a lab full of ideas, a crossroad of skill, a launch pad for a new generation of jurists who want to make a difference. The work season The debates and meeting of this day will be the tool we'll be using to build a new strategy which will help us to face with determination the global changes what await us. But we should never forget that law is not just a set of rules and procedures. It is, first and foremost, an instrument of justice, fairness, and the protection of fundamental rights. We, young European lawyers, have a responsibility to defend this principle firmly to ensure that the law remains a force of democracy and freedom. I'm certain that this conference will be a strong, stimulating and enriching experience for all of us, and the innovative ideas, strategies, collaboration, and concrete solutions will emerge to address the challenge of our time. Thank you and enjoy your time here.
So thank you very much to the speakers for the welcome remarks. Now we are asked to the moderators, Giulia Tommasini, she is the secretary of AIGA Roma, and Emanuele Porchetta to join us. And I ask to the first speaker for the first session to come here. Thank you very much. Enjoy.
Good morning, everyone. For those who haven't met me yet, I am Elia Evangelista, Italian lawyer, Advent and CTM associate, and IBA member. Just let me spend some time for voicing out how happy I am today for having the IBA conference in Rome. Again, it's been a while since the last time. And also to say how grateful I am for having the opportunity to shed some light on the first topic of the day, which is, as you can read, the environmental strike, and to back up in doing so Professor Riccardo Sallustio, which due to very last minute issues couldn't be physically here today, but still is going to spread like his massive knowledge on the topic through Google Meet's connection. So good morning, Riccardo, and thank you again for carving out some time and succeeding in being here today. So let's get down to business, and let's start, with a little memory I had, as soon as I got in touch with this topic and the idea of this presentation on environmental stripe. And my mind got back to the Before the Flood, which was a documentary directed by Leonardo DiCaprio in 2016. It was like a great one. And there was like this kind of dialogue at a certain point between Leonardo DiCaprio and Barack Obama. And the whole thing, was around climate change and the potential impact of climate change on the world. And, at the end of the conversation, it got like Barack Obama, like it's a national security matter. And also, the closure, the final sentence was like, it's time to take action. It was 2016. Bad news is that as of today, 2025, I'm not actually sure that we took action, and listen up, climate change is still happening and it's getting worse and worse. So basically, the climate change and the whole environmental transition can have a huge impact on work. And just treat yourself with a few number facts, just in case. By 2030, 2.2% of the working hours will be lost due to high temperature. The most impacted sectors are going to be the agricultural and the construction one, which are going to cover more or less 60% of the impact. In 2022, which is like the last updated data that we have on the point, only 23% of the collective agreements addressed the environmental transition issue. Also, the whole climate change will worsen, will heighten the already existing inequalities. As you can see in this prospectus, which is based on the Gini index, the inequalities have been happening, in the last 30 years. And probably the climate change, if not properly addressed, will worsen, further worsen this whole situation. So it's time to give some definitions just to know the cards with which we are playing today. What is green transition? Green transition is like a very complex phenomenon with an impact on the social and economical situation involving multiple productive sectors. Which brings me to just transition. Just transition is the process of greening the economy, but leaving no one behind, and so creating decent work opportunities and keeping an eye on the social balance. The environmental strike is then, the strike put in action to advocate for a just transition and/or for environmental sustainability, also when it comes to climate change. So when it comes to environmental strike, we have a lot of legal reference, and the legal background is quite wide-ranging, stretching from the supranational until the Italian Constitution. Just as an example, I want to mention the resolution 76-300 of United Nations, which in July 2022, stressed out the very close connection between nature and human rights. Also, the preamble of Paris Agreement in 2016, put a stress for the first time on the definition of just transition. And then COP24, COP27, COP26 and COP27 elaborated more on the whole concept, coming to the conclusion that the private sector is like the crucial point when it comes to enforcing the just transition's goals. How not to mention also the ILO guidelines, which repeatedly put the stress on the fact that the strike is a crucial element in order to enforce social and economic rights. Articles 8, 10, and 11 of European Convention also matter, especially as defined in April 2024 by the EU Court, which actually recognized the right to have a natural protection from the side negative effects coming from the climate change. Italy is no exception, and with constitutional review in 2022, the concept of sustainable development was brought in Constitution. If you put this together with the concept of actual equality in Article 3, right to work and right to participation in growth of society in Article 4, right to health, Article 33, 32, and right to strike, Article 40. That's where the environmental strike and the underpinning trade union activity lies. And it plays a key role, in the sustainable transition and in the concept of actual equality. Also around Europe, something is bubbling up when it comes to this concept. In Spain, there is like a wide debate concerning the environmental strike, and the doctrine came to the point to recognize the full legitimacy of this kind of strike. Professor Gutierrez did it in the last right on the point. Also, a groundbreaking decision of the Constitutional Federal Court of Germany, less than 1 year ago, recognized the fact that individuals have a right to get protection from the negative sides coming from the climate change. But in order to have a wider picture, it's also necessary to get a full ESG perspective on the topic, which is not going to be an easy job due to the fact that the geopolitical situation today is totally messed up. But still, Ricardo will do it greatly. So Ricardo, word is yours. And thank you again.
Thank you. If you can move to the next slide, please. Yeah. So, Elia, can you move to the next slide, please? Thank you. So, thank you, everyone. I mean, what's happening at the moment, especially in the US, has created a so-called ESG backlash. So what we are finding is a situation where politicians are actually attacking some of the principles which have been enshrined in the Sustainable Development Goals throughout the last 15 years. So what we have a bill in the US Senate which has been submitted by a senator from the Republicans, who eventually is preventing US companies from complying with due diligence obligations, which would be introduced as a matter of European law through the Corporate Sustainability Due Diligence Directive. And then eventually we have also an executive order that President Trump has issued to suspend temporarily the US companies from applying the Foreign Corrupt Practices Act, which is a key element in US legislation to ensure that companies do not corrupt foreign officials. Equally, what we've seen in the EU is through the so-called omnibus regulation, a reduction of the scope of the Corporate Sustainability Due Diligence Directive, which deals with the violation of human rights and in the value chain as well, and with the environmental issues that affect European companies and non-European companies. And so what we have also a reduction of the scope of the transition plans of European companies, which do not know only will only be need to be adopted and not to be put into effect, which is going to be a major change in how the corporates in Europe will have to do their own transition. Equally, we are restricting the scope of the reporting obligations on companies on sustainability by putting a threshold. So companies which are below 1,000 employees will not be mandatorily required to address sustainability issues. Now, why this is important in relation to a strike? why this is relevant. What these new pieces of legislations, if enacted, will actually bring to the table is that US companies and small and medium European companies will effectively be allowed to go undetected. Now, to give a bit of background, the way sustainability reporting works in Europe, you have an involvement of trade unions, an involvement of employees in the materiality assessment that is trying to address and identify any potential sustainability issues within the company and its value chain. So what's happening as a result of that? That you suddenly find yourself in a position that there are companies who actually report and act, companies which actually deal with the just transition issues within their transition plans, and companies that don't. Companies that are not required to report, they're not required to adopt the transition plans, they're not allowed, or whether they're not mandatorily asked to address in a plan and engage with the trade unions on these issues. So you find yourself, depending on the size of your company, so whether your mother company is a US company or not, you find in a completely different scenario in terms of information that you get, in terms of rights. Because eventually what you're missing is the data, is the information that underpins the strategy and the business model of your employer. So we are in a situation where certain type of companies would be exposed to an unjust transition because they don't have the elements, or the employees of this company will be exposed to an unjust transitions because obviously the data are missing and because the relevant due diligence obligations do not fall on the employer. So this is an issue which also triggers potentially reputational issues. And if we look at from the perspective of the employee, there's clearly an issue of the substantial inequality. So we find ourselves that this backlash is creating a substantial inequality between employees of different companies. So the issue really is now, what's going to happen? Are the employees entitled, given this underpinning issue, to call a strike? So I'll leave the word with a solution and the conclusion to Elia.
Thank you very much, Ricardo. It was very much insightful, and it lets me try to put on the table some conclusion. I mean, we have put so many different points, and it's time to draw some conclusions. And so the question is the environmental strike legitimate under Italian law? Is an environmental strike advocating for a sustainable model or a direct value chain admissible? In other words, is just transition an individual right, enabling an individual worker to put in action a strike? My conclusion, our conclusion, on the basis of the considerations we shared, and on this background, which is the European and Italian constitutional background, is a positive one. But just let me make a step back. When it comes to pure political strikes, of course, the strike is not going to be, under a labor law standpoint, a legitimate one, because it's not depending on an action which is under control of the employer. On the other hand, of course, a strike deriving from an unfulfillment of the employer, which is acting in formal breach of a collective or individual agreement, in that case, of course, the strike is going to be legitimate, fully legitimate. Today, we are trying to go into the yellow area over there. So just to see what happens in case there is no a formal breach, but the model of business put in place by the employer is unsustainable. And so, as unsustainable, is going to put at risk the future prospects and also putting in place a reputational risk, which is going to impact on work and employment perspectives. So the answer is the just transition is all right, because the just transition is going to imply the enforcement of a number of other rights: health, work, participation in society, participation in economy, and in the process of growth of the society. So basically, employees have a vested interest in sustainability and in just transition. And in this context, the environmental strike and the underpinning trade union activity is a very, very crucial instrument to level the playing field, to guarantee the participation of the social parties that, as Ricardo said, is narrowing now due to the geopolitical dynamics. And so it's basically the key point for the democratic sustainability of the process of transition, for the just transition. So as they say, just for concluding, make it green, make it just. Thank you for your attention, and thank you again, Ricardo, for the time you dedicated to us.
Thank you.
So, of course, sorry, I'm fine. Of course, if you have any questions, we are totally available. I mean, if we have time, please confirm. And in any case, feel free to reach out. Here you find our email address and also our website as Advanta NCTM. If any of you ask a question, I will be more than happy to address it. Question? Oh. Yes. Yeah, that's a good one, actually. Thank you. Thank you for the question. Yes, I would say so. You know, based on the considerations we shared today, I would go like for the full legitimacy of this kind of environmental strike based on unsustainable business model. And so the first point is that like trying to sanction an employee for this kind of strike based on lack of futurability and the kind of concept and the kind of value chain the company applies, you risk to go through an anti-trade union conduct. And believe me when I say you don't want it. Second point is also a reputational point. An environmental strike based like on this is basically an action put in place by the employee and embracing a concept of sustainability, which is very much aligned with the whole ESG idea. And I think it's a very, very positive concept, you know, from the company, from the employer, trying to have a positive approach to this kind of thing, maybe trying to open a table of confrontation with the trade union organizations. But in any case, I would exclude the idea of considering a sanction for the employee. Any other questions? So I guess no. I thank you again for your attention, and thank you.
So thank you, Professor Sallustio and Mr. Evangelista, for sharing with us your expertise on a topic that is already having a substantial impact on employment law, but will should deserve more and more attention for the oncoming future too. I'm glad, and it's a pleasure and an honor for me to represent today the Rome Young Bar Association while moderating this conference. And I don't want to take any time from our speakers, so I would say that it's time to leave room and welcome the president of Milan Bar Association, Mr. Antonino Lalumia, together with the general counsel at Legans law firm, Ms. Valentina Masi, that will and they will be sharing with us their consideration on the topic of the Italian Code of Ethics, challenges posed by society and new clients' need. So, Mr. Alumia, Ms. Masi, the stage is yours.
Good morning, everyone. Dear colleagues, I'm particularly honored to speak here today as the president of the Milan Bar Association. I would like to briefly introduce the topic of the evolution of the legal profession and how we should work to encourage its growth, especially for young colleagues. And so I thank European Bar Association, AIGA, and Conferenza Giovani Avvocati. And so I start with a question. Is the legal profession truly keeping up with the times? In a rapidly evolving world, the legal sector faces a crucial challenge to innovate while preserving the fundamental rules, the fundamental values. The ongoing reform of the professional law represent not just a necessity, but an extraordinary opportunity for growth and transformation. In the recent essay, Noi e la macchina, un'etica per l'intelligenza artificiale, The Machine and Us, an ethics for the digital era, Father Paolo Benanti highlights the importance of maintaining the right course of the technological era, where progress is shaped by the intersection of ideas and facts. This insight is particularly relevant for the legal profession, which must now navigate a changing landscape with clarity of purpose, balancing adaptation with a long-term vision. Society is constantly evolving. New technologies, shifting markets, and increasingly global communication are redefining the role of lawyers. To remain competitive and meet the needs of the diverse and international clientele, legal professionals must explore new areas and practice and rethink how they operate. But this shift cannot be left to chance. It requires an updated regulatory framework that both safeguards ethical standards and expands professional opportunities. And so I appreciate that opportunity to speak on a topic of great relevance and importance to our profession, informative advertising for lawyers. This subject lies an intersection to ethics, innovations, and competitiveness, making it essential to approach it with a balanced perspective that respects regulation while addressing the needs of an increasingly dynamic market. We live in an era where communication has become an essential element in every professional sector. The way lawyers communicate their services has changed dramatically compared to the past, and our profession cannot ignore this transformation. The challenge is to ensure that information is useful and correct without slipping into commercial excesses incompatible with our role. Informative advertising should not be seen as a mere self-promotion, but rather as an opportunity to bring citizens closer to the justice system, providing them with clear and transparent information about lawyers' skill and specializations. In a world where information is available at the click of a button, it's crucial that citizens can choose their legal representative based on objective and reliable criteria. The proper communication of a lawyer should not aim to persuade clients with aggressive marketing techniques, but to inform them in a clear and truthful manner, enabling them to make an informed decision. Professional ethics require that any form of advertising maintains an high standard of dignity and seriousness, in line with the lawyer's social role. The current regulations in Italy are particularly restrictive compared to those in other European countries. The Code of Ethics for Lawyers, established in Article 17, 45, 37, and 57, non-negotiable principle of transparency, correctness, and truthfulness. A lawyer's communication must not be misleading, defamatory, or suggestive. Not sure it constitutes an attempt to solicit clients. However, this regulatory rigidity can be a limitation in an era where competition is becoming increasingly fierce and effective communication can make a difference, a real difference. The risk is that Italian lawyers may find themselves at a disadvantage compared to foreign colleagues who operate in more open and competitive markets. Looking at Europe, we see that many countries have adopted more flexible regulatory models. In France, Germany, and Spain, for example, lawyers can advertise their services more explicitly, provided they do so truthfully and currently. In the United Kingdom and in the United States, legal advertising is widely accepted, with law firms investing in marketing and communication to attract clients. The system suggests so that modernizing Italian regulation may not only be desirable, but necessary to ensure that lawyers can compete in equal terms with foreign colleagues. The key, however, is to strike a balance between openness to informative advertising and the preservation of professional ethics. The advent of the new technologies has revolutionized how professionals communicate with the public. Websites, social media, podcasts, legal blogs, and informational videos are increasingly used to share knowledge and reach a broader audience. The use of the social media by lawyers raises complex ethical questions. To what extent can a lawyer promote their services on a digital platform without violating ethical principles? Where is the line between the dissemination of educational content and covert advertising? This question necessitates a broader reflection on the regulation of the legal communication in the digital context. In an increasingly complex and competitive legal market, communication is not just a tool, it's a fundamental pillar of trust between lawyers and their clients. Today's clients are more informed and selective than ever. They seek not only legal expertise, but also professionals who demonstrate transparency, credibility, and a clear track record of success. Your lawyers must embrace strategic communication as a means to establish a strong and lasting relationship with their clients. This doesn't mean engaging in aggressive marketing, but rather adopting a professional and informative approach that highlights their experience, areas of expertise, and case history. In many jurisdictions, lawyers can showcase their professional journey through well-structured profiles, case summaries, and client testimonials practice that help build trust and foster informed decision-making. However, current ethical regulation in Italy impose strict limitation on how lawyers can present their expertise. The prohibition in Article 35 of Code of Ethics, which prevents lawyers from mentioning clients' names even with consent, it's a significant barrier to transparency. In contrast, many Europe countries allows legal professionals to demonstrate their track record, providing potential clients with concrete insight into their experience and competencies. Updating these communication norms would not mean compromising the dignity of the profession. It would align Italy with international best practice, allowing lawyers to position themselves more effectively in a globalized legal market. By adopting a clear, ethical, and structured communication strategy, lawyers can reinforce their professional credibility and respond to the growing demand on transparency and accountability from their clients. Actually, so a modern approach to the legal communication is not about self-promotion, it is about ensuring that clients can make informed choice, fostering relationship built on trust, on strengthening the professional role in society. And so reforming the professional law is not just a technical adjustment, it is a necessary step to revitalize the legal profession and ensure its competitiveness in the European and global landscape. The legal sector must embrace both tradition and innovation, maintaining its role as a defender of rights while adopting a forward-thinking and open approach. Too often mass discussion about the attractiveness of the legal profession focus on the number of lawyers and so-called crisis of vocations. But the real question is, what the future are we offering to young lawyers? If we want a strong and competitive profession, we must look ahead, redefine its possibility, and build a future where legal profession can thrive in a dynamic and evolving work. Thank you for your attention, and sorry for my voice, but I'm not feeling very well.
Good morning. I'm very glad to be here in this such interesting event. Another rule that needs to be reformed of our Italian deontological code is Article 24 about conflict of interest. There are two important aspects that need to be underlined. First aspect, it's time to specify that the conflict of interest must be assessed in relation to the same matter or a related matter and not in relation to the identity of clients, embracing an essential and not subjective logic. This approach has been adopted by all the other countries, both of civil law and common law, and also the Code for European lawyers has adopted this approach and refers to the matter and not to the identity of clients. And we need to reform this rule under this aspect. Second important point, we know that Article 24 does not provide anything about the eventual consent of the clients. Article 24 does not exclude the relevance of the eventual consent, but we know that the position of the Italian National Bar Association is granitic in stating that the eventual consent of clients is not relevant to override the conflict of interest. But we also know that this position refers to judicial proceedings where a stricter interpretation of Article 24 is perfectly justified. But we may ask if we can reach a different conclusion in relation to extrajudicial activities, where we do not have the same needs of safeguards than in the judicial proceedings, and we have also to face specific clients' needs. Today, clients contact a single law firm to asking to act as a transaction counsel in the negotiations towards a common contract or agreement in consideration of the advantages in terms of cost and in terms of speed of executions. provided that should a dispute arise from the negotiations, lawyers is obliged to give up both the mandates. And it's important to give a look to this regard at the other countries to easily understand that the other countries has adopted a more open approach than in Italy. For example, in Germany, the conflict of interest may be overridden if there is the consent of clients and if specific measures to protect the confidential information of clients have been put in place, the so-called Chinese walls. In England and Wales, if clients have a common interest or are in competition for the same object, the conflict of interest may be overridden if the following conditions are met. There is the consent of client, the Chinese walls, and the lawyers deem appropriate to act for all these clients. And also in Spain, the consent of client may override the conflict of interest in relation to extrajudicial activity. And also the code for European lawyers does not contain limitation similar those set out in Article 24. And then also in this case, it's important to start a deep reflection on Article 24 in order to make Italian lawyers more competitive also in a global scenario and able to face the client's needs. Another rule that needs to be reformed is Article 68 that states that lawyers can bring an action against a former client only after 2 years from the termination of the professional mandate. Also in this case, Article 68 does not provide anything about the eventual consent of the former client. And to this regard, the position of the Italian National Bar Association is not granitic, and there are at least 2 sentences where the Italian National Bar Association has stated that the consent of the former client may override the limitation set out in Article 68. And also in this case, it's important to give a look at the other countries because, for example, in Spain and France, there is not such a limitation unless there is the risk to breach the confidential information of clients or there is the risk that the information obtained from the first client may favor the second client. In England and in Wales, this limitation exists only if there is the risk to breach the confidential information, but may be overridden if there is the consent of the former client. And then also in this case, it's important to start a reflection on this article and to consider also that this limitation is not only a limitation for lawyers, but also for clients, because in this case, a client cannot contact a law firm for this limitation, also if this law firm has a certain organization or a certain areas of specializations useful and important to fulfill the professional mandate. And then I think that it's time to really reconsider our rules of the Italian deontological code and the comparison with the deontological rules of the other countries is more important because Italian lawyers are bound by much more severe rules. Thank you for your attention.
So thank you to our prestigious speakers for sharing with us their consideration on this time on a topic that is of full interest of all of us and should be of special interest for young lawyers in particular, regardless of our specific field of competence. So I guess now it's time for a short break. We can have, 20-minute breaks for having some coffee and to refresh a little. And we resort for, yes, in 20 minutes, the works of the conference.
And topics to be addressed. I am Giulia Tomassini. Let me say just that I am really pleased to be here. Thank you to EYBA and of course to Giulia Guagliardi and Aiga Roma for having organized this wonderful event. This second part will be started by Daria Pastore and Federica Pomero, both partners at Legans Law Firm. They will discuss about challenges and trends in M&A disputes. So let's dive right into this matter, and I leave the floor to you.
Good morning, everyone. We're very happy to be here, and thank you for hosting us. First of all, we would like to introduce briefly our law firm. We are both partners, as we were mentioning before, of Legans. Legans is an Italian law firm, mainly focused on extraordinary transaction corporate activities, and also, of course, a dispute resolution department. In our experience, we have seen in the last years a surge in deal activity, private equity transaction, and a significant rise has been registered at international level in the number of pre and post M&A deal disputes. All the arbitration institutions at international level register in their report an increase on M&A disputes. This is not actually our experience as M&A lawyers in Legans. We say this with, I have to say, a certain level of pride without being arrogant, because we think as M&A lawyer that our main purpose in the interest of clients is to minimize, to reduce as much as possible any pre and post M&A deal claims. We work together with Daria, with our litigation department, since the beginning of the transaction, we say before the deal, in order to try to minimize such risk. Of course, we always say in M&A, expect the unexpected. It's not easy to have a share purchase agreement that avoid any possible risk. This is just the purpose, but then there is the reality. Any transaction has its own peculiarities, but the purpose in our experience is to try, since the beginning of the deal, since the due diligence activity, to highlight in the parties' interest any issue on the table and try to address it in the transaction documents. Going to the possible claims that we have seen in our experience in the different phase of the M&A transaction, we can start, of course, from the negotiation phase. Normally, negotiations are a non-binding phase of the transaction, so we don't expect to have in the agreement we sign, memorandum of understanding, term sheet, binding provision, except for normally exclusivity and confidential provision. These are normally clauses that we don't see in court. Normally, we don't see claim, of course, I'm speaking about our experience as Italian lawyers, we don't see many claims brought to court or referred to arbitration concerning this kind of provision. These are more, we say, deterrent that the party use to try to inhibit each other from breaking confidentiality obligation, breaking exclusivity, rather than the actual claims we work on. The part that is most interested in the negotiation phase of the transaction mainly concern interruption of the negotiations. In the Italian jurisdiction, there is a principle of good faith. Probably there is also in other jurisdiction. Article 1237 of the Italian Civil Code expressly set forth that the party need to enter into the agreement and negotiate the agreement in good faith. This is a principle of good faith behavior that it's really important in the negotiation phase. This means that if the party decide to interrupt the negotiation, it needs to have a just cause. Otherwise, it may be exposed to damages for the cost and expenses incurred by the other party who was brought to believe in the execution of the agreement.
And in addition, yes, what is the trends of the court relating to the this kind of claims that are rare in our experience? However, it should be taken into account that according to the courts recently, the bona fide principle is also relating to all the information shared and to be shared with a counterparty. That means that the difficult, let's say, job here is to work together to understand and to find a balance between the strategy and what should be disclosed as, information, because otherwise the counterparty in a potential claim could, raise a claim for breach of bona fide principle as the counterparty didn't mention some information that were relevant. So also, the omission of the information should be taken into account.
Yeah, and also the open points to be discussed during the negotiation are a crucial point. Sometimes parties tend to postpone the discussion of certain open points that they consider potential deal breaker in the deal. But it's important to work with the client and the litigation team to identify the issue that has been brought to the attention of the counterparty since the beginning, because if you want to interrupt the negotiation at a certain point and raise this point as the justification, the just cause for the interruption of the negotiation, of course, this must be a point that has been already brought to the attention of the party, cannot be a new point that the first time is raised during the negotiation. So this is normally the most debated part of the pre-contractual phase. Then we have, many of you, I guess, are corporate lawyer, M&A lawyer, so you know all the phases of the typical M&A transaction. After the negotiation, hopefully, there is the signing of the agreements, share purchase agreement, asset purchase agreement, investment agreement. Of course, it depends from the transaction, but the principal pillar point of the M&A transaction is, of course, the signing. Usually, a distinct moment with respect to the actual execution, which is the closing. In the meantime, between signing and closing, we have the interim period, and many claims can arise during this interim period concerning condition precedents, obtainment of the authorization, no-show at closing or signing of the transaction. What happened to us, for example, was in connection with the issuance of a clearance from the antitrust authority, we have and still have a pending claim because the antitrust authority had issued the clearance. So we could go to closing, but the authorization was subject to remedies. So our client wanted to close the deal, but the counterparty didn't want, because they didn't want to comply with remedies. So even a simple act which seemed not possible to debate on, like the issuance of an authorization, can give rise to an M&A claim. And of course, it's a question of interpretation of the share purchase agreement, in this case, the provision on the issuance of the authorization and the condition precedent related thereto, how the claim will finally end up. Another case that I was mentioning concerned the no-show at closing. We also have this funny experience of the party that didn't show up at closing. So our client wanted to use a specific enforcement remedy that we have under our jurisdiction to force the party and issue an order that replace the act that the other party should have signed and didn't sign. This is highly debated, and of course is not simple. This is not maybe the right moment to open a long debate on that, but just to give you an idea of what can happen during an M&A transaction. Of course, the majority of the claims on M&A are related to the post-closing phase, when we face the typical case of breach of representation and warranties. And Daria maybe wants to give you some examples of.
Yes, as Federica stated, the majority of claims that we face in our experience, but generally speaking, if you see the report of, arbitral institution or generally any report, it's mainly related to the breach, to the post-closing phase and to the breach of rep and warranties. I don't know if any of you have any idea which is the most breach rep and warranties. I don't know if anyone has an idea. I can ask to go to the other slides. Because there are many potential rep and warranties. We have, the rep and warranties on tax matters. That is the most breach one, according to the percentage, of the insurance broker that we analyzed. And then the rep and warranties on financial statements and accounting records. For example, we are dealing with Federica on a case relating to the fact that the buyer is alleging that the seller didn't mention a potential liability in the financial statement. But of course, then our argument will be that in any case, any documents relating to this liability was included in the due diligence and so was disclosed in the due diligence. This is just an example. But of course, it's one of the, also this one is one of the most breach rep and warranties. Then we have the rep and warranties on compliance with the applicable laws and regulations. And this is the most maybe general one, when you don't have anything else, to find, to ask for damages and indemnities. Maybe this one could be, the one. And especially it's very important talking about the trends and challenges, I would say, because in our opinion, this could include also the ESG regulation and applicable laws, which is an issue. It's an issue because that we don't have a defined and certain, let's say, set of rules in the European Union and in Italy. So it's changing always. So there is not certainty about this ESG regulation. And so it could be a very broad concept. And that's why it's very important to work together to understand how to write the rep and warranties, how to properly write the rep and warranties. We have other, let's say, potentially, breach of rep and warranties, the authorization and concession, as well as litigation and pending claims, because usually the seller represents and warrants that the target company is not party in any claim and litigation. And there is an example about how properly write a clause. Because according to to make the difference, to minimize, even if, it's there is always the unexpected in M&A transaction, we can try to minimize this risk and so to write properly the clause. And one case analyzed by the Court of Milan, the rep and warranties was written as the target that does not have any litigation pending against the target. So then after, the closing, the buyer found different proceedings where the target was not, the defendant, but was the plaintiff. However, the indemnity and the rep and warranties was linked to the legal fees. So, it doesn't care if it is, the plaintiff or the defendant. And in that case, the Court of Milan stated that there was a breach of the rep and warranties because the wording against should be interpreted, according to the bona fide principle, and so in this case it breached because there were, actually the litigation pendings involving the party. So that's why maybe writing, a clause by stating, that there is no litigation relating to the party, or involving the party would be more appropriate and preferable. And of course, like generally speaking, always about rep and warranties. In the potential litigation and potential liability, also the greenwashing should be taken into account because there are many potential claim that could arise from the marketing communication, and maybe we should think about a due diligence also potential claims relating to the greenwashing, as well as, of course, climate change litigation could be an issue, especially considering that in Italy we have recently reformed the class action regime. So also, a small claim could be potentially a big claim. So also in analyzing the documents, let's say, and the diligence, and in writing the rep and warranties, also this issue as a new challenge should be taken into account. I would say maybe I will jump to the mechanism that should be used for M&A claims, the dispute resolution mechanism, sorry. Because one of the main questions that we receive from our corporate department is, should I insert an arbitration clause in this SPA? And actually, we noticed that the 75% of the M&A claims are brought before an arbitral institution. This is, and I don't know why, but usually you hear that the M&A disputes should be decided by an arbitral tribunal. Actually, in our opinion, in our experience, there is not an answer for this. Even if, usually there are in the M&A transaction arbitration clause included, we should see and we should analyze the features of the transaction and the features of the different, dispute resolution mechanism. And then we say always, arbitration versus court litigation, but we have also mediation. And actually, in our experience, we are seeing that the parties prefer to have different steps of dispute resolution mechanism. So the first mechanism is, for example, a technical committee. For example, in very, technical stuff and issue, depending on the industries, as well as, mediation procedure of different kind, and then arbitration or dispute resolution, so jurisdiction clause or arbitration clause. The difference, I know many of you knows the differences, and they should be taken into account, also considering the value of the transaction, because actually in Italy the arbitration is much more costly than the litigation court. Differently from other countries, like in the UK, the court fees in Italy are pretty low compared to the arbitration cost, of course, and then for high value, of course, transaction, it could make sense. Otherwise, it would be preferable to have to go to the court, and the duration is lower in the arbitration, of course, and so that should be taken into account also, because yes, it's much costly, but the duration could be shorter and lower, as well as the parties that are involved, because if you have like two Italian parties, to be honest, maybe it does not make sense to go to an arbitration court. While it makes sense if you have like different parties from different jurisdictions, and so this is also because they prefer to have a neutral court, and in English, yes, discussion, and the language at least for now, could not be chosen by the, before the Italian courts, even if there is high discussion about, proceedings in English also in Italy. However, this is not something provided. All the brief and all the acts are in Italian. While in the arbitration clause, it is possible to decide the language of the proceedings, of course. Before, and this is the new trends maybe, before we stated that under Italian law, it is not possible to obtain interim measure procedure, but also this has been changed after the Italian procedural reform, and now also arbitrators could issue, interim measure procedures. So this would be not anymore a difference, but in any case, the enforcement of anything, including the enforcement of, let's say, the document production against third party, request to the authorities to produce documents. This kind of means are, easily enforceable under, a proceeding within the courts, while it's much more difficult to obtain, the enforcement or a request to the public authorities, for example, or to a third party to produce documents within an arbitration procedure. So that's, all, issue that should be taken into account. I don't know if we are out of the time, so I'm looking at so maybe yes.
Thank you. If there is any question, otherwise, I would really like to thank you for your discussion, which truly shed a light on the complexities around M&A transaction, even in this short time due to constraints, of course. And I would like to call on the stage our next speaker. Thank you again. Thank you.
Thank you.
So please, Professor Paolo Pinto di Albuquerque. I hope I have pronounced it correctly. Good morning. Thank you. Professor Pinto is a former judge at the European Court of Human Rights, and he is also a professor at Cattolica Lisbon School of Law. He will provide us today with valuable insights on extended confiscation in Europe, which is a highly relevant topic given its implications for legal systems across the continent. So, Professor, I leave the floor to you. Thank you.
Thank you so much for the invitation. It's a pleasure to be here. I was a couple of years ago exactly on the same room talking about a different issue, also very relevant. It was, I believe, about the implementation of Article 3 in Italy with regard to the new crime of torture. Now I'm going to talk about a different issue, but it is also very relevant to Italy, which is confisca senza condanna, confisca preventiva. Basically, the confisca based on the law anti-mafia. I'm not going to talk about specific cases that are pending. I'm not going to talk about the Cavallotti case, which is a very important Italian case pending before the European Court of Human Rights right now and waiting for a decision that will be taken by the court very soon. For several reasons, I cannot talk about this case. One of them being that I may be involved as an expert on this case. But I can talk in general about this issue. And I can present to you the reasons why I believe we have here a major legal problem that is not only relevant to Italy, but to all Europe. Confisca senza condanna, confisca preventiva, is a problem that has been, in a way, brought to the table by Italy during the discussions of the new directive on confiscation, the new EU directive on confiscation from 2024. Basically, what some experts have said is that the Italian model was adopted by Europe, by the European Union. And if that is so, then the Italian government would have a major card to play in Strasbourg saying, listen, we now have a European consensus on the Italian model. This would be a major playing card in the procedure in Strasbourg in favor of the Italian government, saying there's now a European consensus at the level of the European Union on the basis of the Italian model. The Italian model was adopted by the European Union and was imposed by means of a directive on all EU member states. And in order to argue and to reinforce this argument, they would say Article 16 of the new directive basically transposes into EU law the confisca preventiva. Some experts have argued in this direction. What I can bring today to you is my reservations to this argument. I do not agree with this argument, and I think we cannot and should not make an assessment of the situation at the level of the European Union without being quite clear about what we are talking about. I think, first of all, we should understand that confisca senza condanna in Italy has been subjected to a development that was unexpected. Now is a general means of criminal prevention, not only against mafia, but against any sort of crime. Any sort of crime, which does not necessarily relate to criminal organizations. So now this is a general instrument of criminal prevention, of criminal deterrence. That is not the purpose of the measure of Article 16 of the directive, which is aimed at fighting against criminal organizations. So the purpose itself is different. Second, confisca senza condanna and confisca preventiva in Italy is basically possible even without a criminal proceeding. More, it is possible simultaneously with a criminal proceeding. More, even more, is possible after the acquittal of someone who has been accused and convicted. Imagine that someone is accused, convicted, but then on second instance or at the level of the Court of Cassation, the conviction is revoked. Then it is possible, still possible, to apply confisca senza condanna, confisca preventiva. This has nothing to do with Article 16 of the directive, which presupposes always the existence of a criminal investigation. The opening of a criminal investigation, within which there are assets that will be confiscated, apprehended, and then confiscated because they have a special relation with the profits made by a criminal organization. There are different purposes, but there are also different requirements. So we cannot say that the instrument of confisca preventiva, as it is implemented in Italian law, is exactly the same that is provided by Article 16 of the directive. That is my first preliminary conclusion. Second, confisca senza condanna is interpreted by the Court of Cassation and the Constitutional Court here in Italy as not being criminal in nature. It's not criminal law. It's preventive law, it's criminal prevention. The Court of Cassation has said that during some time it has said that it is a security measure. Now it is saying that is something quite different. It's repristinatoria in nature. So it tries to reinstate the situation before the criminal assets were acquired. Well, the directive, it's a totally different story. Recital 46 of the directive says that the presumption of innocence applies. Recital, I repeat this, it's extremely important. Recital 46 of the preamble of the directive says that the principle of presumption of innocence applies to all forms of confiscation of this directive, including NCB confiscation, including non-conviction-based confiscation. And this means that the guarantees of Article 48, 47, and 48 of the Charter of Fundamental Rights apply, which means that defense rights, criminal procedure defense rights apply. This means ultimately that we are faced with a criminal measure, a criminal law measure. If the presumption of innocence, if the guarantees of criminal procedure apply to all sorts, all different forms of confiscation of the directive, this means that this is an instrument of criminal law. The instruments of the directive are instruments of criminal law, all of them, including Article 16, including this form of NCB confiscation. So it has nothing to do with Italian law, because the Italian Court of Cassation and the Italian Constitutional Court do not accept that the presumption of innocence and the guarantees of criminal procedure apply to confisca senza condanna, to confisca preventiva. And why does the European Union apply presumption of innocence and the defense rights in criminal procedure to this form of confisca senza condanna? For a very simple reason. Because the grounds for the competence of the EU to legislate on this issue are Article 82, paragraph 2, 83, paragraph 1 and 2 of the Treaty on the Functioning of the European Union, which means that the only grounds that the EU can invoke to justify legislation in this field of law is criminal law. There can only be EU legislation on this field if the instrument created by the European Union has a criminal law nature. Otherwise, they would not have a ground, they would not be grounded on the Treaty on the Functioning of the European Union. So, for reasons of competence, the EU can only legislate on confiscation if the instrument created has a criminal law nature. That is the reason why the EU could not create a civil forfeiture instrument, it would not have competence for that. Article 82 and 83 of the Treaty on the Functioning of the European Union do not allow for the European Union to create a civil law instrument. The only instrument that the EU could create is a criminal law instrument. That's why the preamble says that the criminal procedure guarantees apply to all sorts of confiscation. Otherwise, the directive would not have a ground on the treaty. It would be an unlawful directive. So the directive can only create and impose on the member states a criminal law instrument, meaning that the criminal law guarantees principle of legality, proportionality, all apply. And the criminal procedure guarantees all apply, including presumption of innocence. This means that the nature of the instruments created by the EU is criminal. This is pure criminal law, which has nothing to do with the Italian situation, nothing. So the argument made by some doctrine and by some MPs, some members of parliament in Italy, and also by the Italian government, that the model of Italy was absorbed by the EU, in my view, is a failed argument. Now, the issue is, if we cannot invoke EU law to justify the confisca senza condanna, the confisca preventiva, can we invoke an European consensus on this? Other than the EU law, can we invoke other sources on this? Well, in my view, we cannot. We cannot because if you do a comparative law study of the situation in Europe, and if you go beyond Europe, if you include other non-European countries, and even if you include soft law materials like United Nations, like World Bank sources, like many other soft law instruments, you end up with the conclusion that all these sources point in different directions. They propose different models. One of them being the civil forfeiture model based on civil law, with a standard of evidence that is exactly like in civil law. Others, they present a different strategy. So it's very vague. You cannot really argue on the basis of European consensus. There is no European consensus on this issue. And if you go beyond Europe, if you include the non-European states like Australia, like Canada, like United States, the situation is even more diverse. If you include soft law materials like the FATF, International Standards on Combating Money Laundering, or the Moneyval strategy on anti-money laundering, or the manual on international cooperation for the purposes of confiscation of proceeds of crime of the United Nations, or the World Bank Asset Recovery Handbook, if you include all these elements, you end up with a very diverse picture of NCB confiscation. So you cannot really invoke this European consensus. This is my second conclusion. First conclusion: EU law does not justify confisca preventiva. As I mentioned, the directive of 2024 does not justify confisca preventiva. It's a totally different means of combating proceeds from criminal organizations. Second, you cannot argue that there is a European consensus on this. Third, you have very serious problems with confisca preventiva in Italy. First, and I would like to limit my observations to two basic issues. The notion of appartenenza. Appartenenza, it's a central notion, pivotal notion of the anti-mafia codice that justifies that all those which belong to the sphere of influence of criminal organizations can be targeted by these measures. The problem is with the vagueness of this notion of appartenenza. If you read the case law, you get a very confusing and very confused notion of appartenenza. For me, as a criminal lawyer, I'm stunned. It's very confusing. With all due respect, the case law is a mess. It's arbitrary, purely arbitrary in the definition of this concept of appartenenza. There's a total lack of foreseeability. Why? Because the notion is not precisely defined, neither by law nor by case law. So you cannot argue that the principle of legality is respected. The basic fundamental principle of legality is not respected because of lack of precision and foreseeability of the notion of appartenenza. First problem. Second problem is the principle of autonomy of prevention proceedings vis-à-vis criminal proceedings. We know that this principle was introduced in Italy in 2008. And the purpose was to separate preventive proceedings from criminal proceedings. And we know what was the purpose. The purpose was to target in the preventive proceedings those that were acquitted in the criminal proceedings on the basis of the same evidence. The exact same evidence could justify confisca senza condanna, although the person on that same evidence could not be convicted. This was the policy choice made in 2008. Now, the principle of autonomy of the prevention proceedings make it possible that you can find someone especially dangerous. You can ultimately reach a finding of special dangerousness of someone who has been acquitted. I have serious reservations regarding this principle of autonomy. Basically, this is a way of avoiding the effect of ne bis in idem. Basically, this is a way of sidestepping and avoiding the effect of the ne bis in idem of the criminal proceedings decision. If the purpose of the confiscation is to target assets that derived from a criminal organization or from criminal activity, in any event from targeting assets that were acquired unlawfully. And by unlawfully, the Court of Cassation means unlawfully in general, not necessarily related to criminal activity. Right now, the case law of the Court of Cassation, of this court, is that it is only necessary that the means are acquired, the assets are acquired unlawfully, in general, not necessarily by committing criminal offenses. Imagine, okay? So how wide the scope is of the targeted assets. If this is the basis of the reasoning, and if this reasoning is looking at the past, not at the future, not preventive, not really preventive, no longer preventive, but more looking at the past and at the previous conduct of the proposto, of the person targeted by the prevention proceedings, then we should say that this is a pena mascherata. This is a pena mascherata. This is a disguised penalty. If this is a disguised penalty, then you have to apply fully all the consequences of criminal law, namely that it cannot be applied after a criminal proceeding has acquired the force of res judicata. Otherwise, you would violate the ne bis in idem principle. You cannot apply a punitive measure which is punitive, which is applied by a criminal court, which is extremely severe. It can annihilate totally the life, as we have seen in several cases here in Italy. It can totally annihilate the financial life of a family, not only of the parents, but also the sons and the grandsons, all of them targeted because of a sin committed somewhere in the past 20, 30 years ago. By the way, there's no prescription for this in terms of the targeted assets. So, in fact, this principle of autonomy raises some delicate issues in the light of the ne bis in idem principle, if you really see beyond the appearances. If you really, and the court, the European Court of Human Rights, asks us to do this exercise, to see beyond the appearances.
Thank you, Professor. If you would like to
come up to a conclusion. Yes, I will. Very briefly, just to say that all these reservations lead me to conclude that the Episcopo case, the recently delivered judgment in the Episcopo case, and more recently even the Garofalo case, have not said the last word, the final word on this regard, and this last word and final word should be said by the Grand Chamber of the Court. I think the cases that were dealt recently, dealt with by the court, the Episcopo case and the Garofalo case, they, in some aspects, they delivered good case law. For instance, in the Episcopo case, there was a finding of a violation of Article 6.2, meaning a finding of a violation of the presumption of innocence. That is great law, great case law, which acknowledges that the principle of presumption of innocence is applicable to confisca preventiva. This is good law. But the Garofalo case came to a different conclusion, to the opposite conclusion. Article 6.2 is not applicable, which contradicts not only the Episcopo case, but GM case also, which is a Grand Chamber case, meaning also the European Court of Human Rights is confused right now, and the final word should be said by the Grand Chamber. A new Italian Grand Chamber case is needed to put clarity in this very complex legal situation. And I hope that the case that I referred initially will bring this clarity. I hope that the judges in Strasbourg will deliver this clarity, because we need that clarity. We need it. Not only the Italians need that clarity, but also in Europe, since many countries are faced with the problem of implementation of the directive of 2024. My own country is dealing with the implementation, and they don't know what to do. The temptation is just to follow Italy, to follow the Italian model, but this would raise many constitutionality problems. Many constitutionality problems. And to avoid this, I think we need a grand chamber judgment that puts clarity, brings clarity to this issue. Thank you so much for your attention.
Thank you. Thank you, Professor, for your compelling discussion. I am quite confident that this topic will be issued also outside this court among our public. So for our final presentation, I am pleased to call on the stage Stefano Mele and Francesco Cercello. Stefano Mele is, good morning. Stefano Mele is partner at Gianni Origoni Law Firm, and Francesco Cercello is a senior associate from the same law firm. They will address another fascinating topic, which is neural rights and mental privacy. So without further hesitation, I leave the floor to you. Thank you.
Thank you so much. Thank you so much. Good morning, everyone. It's a great pleasure for us to be here and to speak about a very interesting and maybe innovative topic. In particular, it's a real pleasure for us to be here with you today to address a topic that is rapidly becoming one of the most critical challenges of our time, that is neural rights and mental privacy. But let me begin by clarifying something very important. When we talk about this issue, we are not referring to traditional concern about propaganda, about disinformation, or the manipulation of public opinion through fake news. That remains a serious problem, but it belongs to the realm of influence over public discourse. What we are discussing today is something much more intimate, much more invasive, much more profound. We are speaking about a battle for our brain. It's not a metaphor. With the rapid development of neurotechnology and artificial intelligence, we are entering, in our opinion, in an era in which it's becoming technically possible to monitor, to decode, and even alter the content of our minds, our thoughts, our emotion, our intentions. What was once the realm of science fiction is now being patented, prototyped, and in some cases also deployed already. The stakes could not be higher. The ability to access or influence mental activities is not just a technological breakthrough, it's a paradigm shift. It challenged the very foundation of autonomy, identity, and human dignity. In this context, the law must act not only as a regulator, but as a guardian of our inner freedom. This is where the emerging concept of neural rights becomes so important. Neural rights are a proposed set of fundamental rights designated to protect individuals from the potential abuse of neurotechnology. We have actually identified 5 key neural rights. The right to mental privacy, aimed at preventing unauthorized access to brain data. The right to personal identity, ensuring the continuity and integrity of the self. The right to free will, safeguarding autonomous decision-making. The right to equal access to cognitive enhancement, to avoiding impairing inequality. And the last one is the right to protection for algorithmic bias, particularly when AI is used to interpret or influence brain activity. To date, these rights are not yet codified under international law. However, we are seeing important early developments. Chile, for example, as Francesco will articulate more later, has amended its constitution to include specific protections for neural data becoming the first country in the world to do so. Among all these, mental privacy stands out as perhaps the most urgent and foundational. It refers to the right of each individual to keep their mental activity, thought, intentions, emotional states, free from intrusion, free from surveillance or manipulation. In practical terms, it means that technology is capable of accessing or influencing our neural activity must be governed by strict legal and ethical frameworks. But today, we face also three major legal challenges. The first one is definition and scope, as you can imagine. What exactly counts as a neural data? Do we mean EEG recordings, brain scans, or should we also include inferred mental states, biometric signals, or behavioral patterns that suggest internal thought processes? The second major legal challenge is consent and autonomy. Can anyone truly give informed consent to the use of their brain data when we ourselves barely understand the long-term implication to give that type of consent? And what happens if consent is withdrawn? Can mental data ever truly be deleted? I don't know. And the third major legal challenge that we see is obviously responsibility and liability. If a neural device influences decision-making, who is accountable for that decision? The manufacturer, the software developer, the user? And how do we draw the line between enhancement and manipulation? These are not questions that we can afford to ignore. The law has always evolved in the response to technological change. Now it must evolve again to protect what may be the most sensitive form of data ever created, our thoughts. So what we can do? Which are the gaps in existing legal frameworks? Where does the law stand today? Francesco, please elaborate about these topics.
Thank you, Stefano. And dear colleagues and guests, as a member of the European Young Bar Association as well, it's first and foremost for me an honor to personally contribute to the 2025 Spring Conference and to share today's debate with you, professionals of the highest excellence. And I will take care of your attention to the lunch break as last panelist, so I will be short. And just continuing the discussion on neural rights and mental privacy, I would like us to take a moment to reflect on whether current laws are able or not to cover and to protect our rights from the use and misuse of technologies. So for us, the main question is the law already able to protect the very essence of the human autonomy when we talk about our brains? So as a matter of using technology to infer data, mainly, from our brains and thoughts, it comes easy for me as well to talk about the General Data Protection Regulation, which most of us may know as the monumental normative step forward in the field of the protection of personal data, actually. The GDPR for sure stands as the best in class at a global level for all around the world, among the global privacy regulation and for all the laws and legislations that take care for protecting personal data circulation and processing as well. So when we talk about the GDPR, we are mainly referring to a recently adopted law just in 2018. It entered into force. And we are talking about a legal source that has adopted a very innovative approach towards technologies and chasing technologies. For sure, we can say in short terms that the GDPR leaves the door open to enterprises and institutions for taking care of the individuals, but this is not, sufficient for protecting our brains when we talk about mental privacy. So what we have to ask is whether a legislative framework like GDPR, as our example on the table, is able to fully encompass the complex and evolving nature of the neural data. So just considering scientific literature on this regard, of course, many propose classifying neural data within the category of sensitive data, which many of you may know as health-related data, political-related data, genetical data, and so on. Maybe this can be a solution, but in our perspective, again, this is not enough, because neural data is not something related to health, it's not something related to our genes, it's something different, it's something new in the context of the legislative frameworks all around the world. So what we can derive from the analysis of the General Data Protection Regulation as an example of laws chasing technologies is that current legal frameworks were designed without considering neurotechnologies. So they are definitely not adequate to address the specificities of the neural data. So, in short, for us it's imperative, and this is maybe the occasion to talk about it, to rethink and redefine the entire category and concept of fundamental rights, because there is something new to deal with. Then, just switching to the global efforts made in this field, we cannot exclude a pioneeristic example that comes from Chile, because as Stefano previously mentioned, Chile is maybe the global leader in the field of neural rights protection, because starting from 2021 was the first country all around the world to introduce a specific dedicated law dealing with neuroderechos. Sorry for my Spanish accent. And from this, Chile led to directly amendment to their constitution. So what we can say, according to our opinion and what we want to share with you, is that Chile is like a standing example of what we can do and what we can expect from our countries. The main topic is whether technology is going faster than our laws, and whether our laws are able to chase technologies. And Chile is, of course, a clear example of the possibility to build new legal framework and, for sure, amend the current legal framework. And in Italy, we are a bit scary about that. And to give all the individuals something comfortable in just imagining what is not relating to the future, but it's a matter of today. Because when we talk about technologies, many of us just make just consider something just in the long term, in terms of time, but it's something here among us. So I'm pleased to leave the floor back to Stefano for concluding remarks.
Thank you so much, Francesco. Yes, in conclusion, we believe there are 3 key steps to move forward on these topics. On this topic, first, we need the international guidelines. This is a global issue, as you understand, and it requires coordinated responses. So organization like the United Nations or UNESCO could play a central role in establishing baseline protection for neural rights. This can help guide national legislator and ensure consistency in how neural rights are understood and protected. The second step is we need national legal frameworks, for sure, specifically addressing neural rights and mental privacy, just as Francesco said, data protection laws like the GDPR have emerged globally. We must now begin to see laws that specifically address mental privacy and cognitive integrity. Third, we need independent, ethical oversight bodies capable of evaluating neurotechnology, and not only for safety, but for dignity of the human. The deployment of this technology in schools, for example, workplaces, or criminal justice systems demands a higher level of scrutiny. Let me conclude with these thoughts. We often hear that data is the new oil, but neural data is not oil. It's not even gold. Neural data, it's us. It's the raw expression of our identity, the raw expression of our beliefs, our desires. If we do not act, protect it, we risk allowing the commodification of the very thing that makes us human. So neural rights and mental privacy are not abstract concepts for legal philosophers. They are the legal shield we must now forge to protect the most sacred space of all, the human mind. Protecting our mind is not about resisting progress, but it's about guiding it. So let us rise to the challenge with the courage, the vision, and the urgency it demands. Thank you so much.
Thank you to the both of you for this thought-provoking discussion and futuristic, let's say. We have a couple minutes more for questions. Otherwise, if there isn't any, I would like to thank all the speakers of this morning session. We have addressed a lot of interesting topics, and we have now reached the end of the morning session. I would like to ask you to stay seated just for 2 minutes for having a group picture, and then I will leave to the lunch break, and we will be back here at 2 p.m. Thank you to all of you for participating.